Hi, it's Mike DelSignore, Massachusetts OUI lawyer. In today's video, I want to talk about a great case result I had in Wrentham District Court. This was a case recently where a client took a breathalyzer and we had to work hard to get it excluded from evidence. Eventually, we did. But with breath test cases, a lot of times I can get the test knocked out of evidence. It just can be for different reasons in different cases. So this client was very patient. They let me do all the motions I needed to do. We assigned the case for trial, and eventually we got the result we wanted. What happens when you're under 21 and you get an OUI charge? You have to do the 24D program if you want to shorten the license loss. So when a client is under 21, they take a breath test and it's over 0.08. There's two suspensions. One, there's 30 days, just like anyone would get for the breathalyzer being over 0.08. And then there's 6 months for being under 21 and blowing over a 0.04. But if you do the alcohol education program, you can have the 6-month suspension waived, and it goes back to 30 days. So this person had already done the 24D program. However, they weren't out of the woods, so to speak. If it was a guilty finding on the OUI, there would have been another 7-month suspension, basically a 210-day suspension for OUI. You can get a hardship on that, but you have to go to the Board of Appeals. That was a process we had in the works to speed up the process, but sometimes the board will require an interlock for somebody under 21. So this was a great result where I was able to get the breathalyzer excluded from evidence. Then the case comes just the observations. The judge or jury is not supposed to consider whether won't consider whether there's a breathalyzer when it's excluded from evidence. So it's not a factor in the case. So keep that in mind. Sometimes people think they took a breathalyzer, the case can't be won. Well, if that breathalyzer is excluded from evidence, it's not going to be part of the evidence at the trial. And then the case will be subjective. It'll be based on observations of driving, field sobriety test. And this was a case where I was able to argue that the client did well in the field sobriety test. I was able to point out different aspects of things that did not show impairment. Their performance on the one-leg stand was able to argue, and the officer acknowledged on cross-examination that their performance was inconsistent with somebody impaired. There's many different clues officers are looking for. They look for how somebody pulled over, how someone gets out of the car, they lean on the car, use it for balance. And these are things that are in their training manual, that signs they would say if someone was impaired, we'd see somebody grab onto the door jamb, see somebody struggle to get their license and registration. So when they don't see those factors, really is a disconnection. It's inconsistent. They'd expect to see those things. So you can argue to a judge, to a jury, that, hey, there's no reason why my client, if they were impaired, wouldn't show these same factors that officers are taught to look for. So maybe something else is going on. Maybe they're not impaired. And that's what we need to get to. We need to get doubt. We need to get uncertainty. And that builds reasonable doubt. So the burden of proof to convict somebody at trial is to the highest degree of certainty. You need an abiding conviction to a near moral certitude. To arrest somebody, you only need probable cause. So it could be that the officer did everything right, but the evidence falls short of proof beyond a reasonable doubt. And that was my argument in the case, that the officer made a valid arrest, but this wasn't a case that gets to the highest degree of certainty because the field sobriety tests really don't strongly support impairment. The driving, there wasn't a major driving reason. There was no crash. It was a brief traffic infraction. The officer didn't ask my client about it, didn't question my client about it once she was on the side of the road. So that suggests, and that's not going to completely destroy the basis of the infraction, but if an officer doesn't really go up to the person after and say, what happened back there, maybe it shows maybe it wasn't that significant. If they don't address it right away, maybe it shows that really the violation was relatively minor. Because I think most officers, if they see a significant violation, they're going to go up to the person and really question about what happened back there. Same thing with alcohol consumption. In this case, the officer really didn't question the client much about it. One statement about it, denied drinking. The officer never said, "Hey, you sure? Are you sure I smell alcohol?" And most officers would do that. So things like that suggest, well, maybe the signs weren't that strong. This was a case where there was a smell of alcohol, but the officer didn't testify that the smell was in booking or in the police car. If someone had drank a lot, in a lot of trials, you see officers testify they smell the alcohol consistently throughout the encounter. So all that stuff raised a reasonable doubt. If you have a case in Wrentham District Court or anywhere in Massachusetts, feel free to reach out. Breath test, no breath test. I'm here to help you, here to give you the best chance of winning your case and let you know the options, help you make the best decision for yourself. Call, text anytime. My name is Mike DelSignore, 781-686-5924.